Ini baris 4 ini pindah depan bisa nggak? Nah, depan. Dipenuhi. Yang saya hormati Ibu Dr. Alma Elmina Marta, kemudian para panitia dan juga mahasiswa khususnya yang ada di Fakultas Hukum UI, baik di Prodi S1, S2 maupun S3. Alhamdulillah wa syukurillah, la haula wa la quwata illa billah, Rabbi syrahli sadri wa yassirli amri wahlul 'uqdatam min lisani yafqahu qawli, amma ba'du. Pada siang hari ini sesuai dengan apa yang sudah kita sampaikan di flyer bahwa kita akan menyelenggarakan kuliah umum dengan tema khususnya terkait dengan hukum dan hak kekayaan intelektual dan bagaimana dampaknya terhadap hukum dan pembangunan di suatu negara. Sehingga memang ada mahasiswa yang ada di kelas ini itu berasal dari mata kuliah hukum dan pembangunan seperti apa yang sudah kita sampaikan di Google Classroom. Kemudian saya ingin memperkenalkan terlebih dahulu. Jadi di sebelah saya ini adalah salah satu dosen yang ada di Aston University di Birmingham. Jadi Birmingham ini adalah kota yang sudah sangat terkenal sekali di Inggris dan kota kedua terbesar yang ada di Inggris. Dan Aston University merupakan kampus yang sudah memiliki reputasi internasional dengan sangat baik. Dan Nadia ini dosen dan juga peneliti dengan fokus area lebih kepada Islamic Financing Law, hukum keuangan Islam, syariat, dan juga terkait dengan hukum hak kekayaan intelektual. Sudah ada banyak publikasi yang dia buat dan beliau sangat aktif sekali. Nah, dulu saya dengan beliau ini sering banyak bertemu saat saya sedang sekolah, dan beliau juga lulusan S1 dari The University LLB Program University of Bradford di Inggris tahun 2008 dan kemudian melanjutkan PhD di Bradford University di kampus yang sama dengan tema riset juga terkait dengan haki di tahun 2016 dan pernah mengambil bar vocational course di BBB College of Law Leeds di Inggris. Dan selain juga menjadi dosen, juga menjadi peneliti, aktif, juga pernah menjadi judicial review consultant, termasuk juga funding consultant dan juga property law consultant. Sangat banyak publikasinya, baik di dalam jurnal, buku, dan sebentar lagi kebetulan saya dengan Pak Budi, Pak Abdurrahman Al-Faqih dengan beliau juga sedang menulis keterkaitannya antara haki, hukum kecerdasan buatan, dan juga bagaimana kebutuhan pengaturan dalam aturan yang bersifat transnasional untuk menghadapi perkembangan-perkembangan itu. Dan insya Allah bukunya akan terbit di tahun akhir 2023 ini. Dan saya kira itu sebagai pengantar dari Nadia. And the technical things will be about, she will speak around 4 slides or maybe 5 slides, just what we did this morning. And then after that, I will try to translate. Jadi nanti akan jadi hari ini saya seolah-olah jadi moderator dan punya pekerjaan tambahan sebagai penterjemah. Jadi pekerjaan saya tidak jauh beda dengan Google Translate. Nah, so please You may start.
Thank you, Dedek. Good afternoon, everyone. No, it's not working. Okay, let's try again. That's better. Good afternoon, everyone. I'm Nadia, and I'm from Aston University in the UK. So a little bit about my university. We are a very business-focused university at Aston. We're based in Birmingham, and outside of London, we are the second biggest city in the UK. We're the most diverse city in the UK. So we have the most cultures and the most ethnicities in the UK. As a university, we're ranked 30th overall in the UK. So we have a very good UK ranking. And in the world, we're ranked within the top 500. Aston has won University of the Year many times. And we have the Teaching Excellence Framework Gold ranking. We are the 15th highest earning university for students, which means we do a lot of work to make sure our students are employable after the degree so that they go into graduate employment. And we have the award for the Entrepreneurial University, because Aston as a whole, everything we do, we train students for the business world. So even our law degree is business and commercial law focused. So is our master's and our PhD programs. We think about how we can encourage students to work and get placement. So during the degree, we support with placement opportunities, and students can then gain those skills and then go straight into work. So it's something we're very proud of at Aston University, and we're really keen to support student development. In terms of a city, Birmingham has so much to offer. So I know London is very, very famous when people think of England, but there is more to England than London. We are based in the Midlands, so in the middle of the country, and we have great museums, we have great shopping, we have amazing food. Maybe Indonesia has better food, but pretty good food for England in Birmingham. And we have so much culture, theatre, activities to do. It's a really good city to live in. It's very vibrant and there's lots to do. I'm not from Birmingham, but I moved there 5 years ago. So it's my adopted city and I really like it. It's a great city to live in. So that's where I'm from and the background to my university. What I'm going to talk to you guys today is about intellectual property at the core, because you're all intellectual property students, right? So you all know about intellectual property. So what's going on at the moment in terms of new developments is artificial intelligence creations. So who should intellectual property belong to? And that's what I'm going to talk to you guys about, from what's going on in the UK, what's going on outside of the UK. I'm going to focus on copyright. If I have time, I'll talk about patents as well, but my main focus to start off with will be on copyright. So thinking about the UK Intellectual Property Office, we are fourth on the Global Innovation Index, which assesses the complete innovation of a country. So it looks at around 80 indicators and it measures political environment, education, infrastructure, and knowledge creation of each economy. So at its core, intellectual property is knowledge-based economy. It's about creating intellectual effort into value. So that's its real focus. So in that score, we're fourth. So we're behind America, Sweden, Switzerland, and then it's us. So we're in the top four. The advantage that the UK has that the other countries don't have is that we also have a thriving Islamic finance sector in the UK. So there's some real activity going on between intellectual property and Islamic finance. So there's a lot of reasons that the UK is really well placed for international intellectual property development. In terms of our IP, we have a table here. So we're split into two. We have registered intellectual property and we have unregistered intellectual property. So our trademarks, patents, registered design rights and plant varieties are all registered and need to be registered at the UK Intellectual Property Office. Unregistered, so this is down to you. As long as you create it, it exists, it's automatic. So copyright, we have no registration for copyright. So as soon as you write it, you put the C, you see the C, and then you put a circle around it, you put your name and date, and that is your copyright. Yeah. We have unregistered trademarks, unregistered design rights, trade secrets, and know-how. Trade secrets, it wouldn't be a trade secret if you registered it, right? So you'd have to keep it unregistered. Otherwise, you lose it. The beauty of trade secrets is if you can really protect them, they can be a trade secret for forever. They don't expire. Neither know-how you keep unregistered until it becomes a patent. So there's some crossover between the table in terms of how that works. So at a global level, you've all heard of WIPO, yeah? The World Intellectual Property Office. Okay, so what WIPO does, it does the minimum standard setting for all intellectual property rights through TRIPS. So every country that is a WTO member has to comply with minimum WIPO standards. So if anybody wants to be WTO joining and having the ascension to the WTO, you have to have the minimum TRIPS level compliance. Now, copyright does not protect ideas, only the expression of an idea. So what that means is that an idea you cannot have a monopoly on. Anybody can have an idea, anybody can create an idea. But the expression, how you express that idea, that's where you get your copyright and that's where you get your monopoly. So copyright gives you the lifetime of the author, which is a long time, plus 70 years in the UK, but the minimum standard is plus 50 years. So anything from 50 to 70 years after your death, you still have copyright protection. So it's a long time. That's a monopoly that belongs to you. Any value, any economic benefit from that goes to you. So it protects all sorts of expressions of an idea. And the most important part to remember WTO is if you don't meet the minimum TRIPS standards, you'll get trade sanctions. So you'll actually, as a country, be impacted financially. And then also it impacts your trade coming in. So foreign direct investment takes place when a country has strong intellectual property rights. And that encourages more investment into a country and protects it. So looking at the Copyright Design and Patent Act that we have in the UK, this is from 1988, we have that copyright is a property right which exists in the originality of the work. So it has to be original. So anything you want copyright on has to have the originality criteria. It's not a very high standard. As long as it fits within one of the works, you can get copyright protection. So it has to be a literary work, a dramatic work, music or artistic, sound recordings, you've got film, broadcast, cable programs, and typographical arrangements, which is a long word for magazines. And then there's 3 steps. So 1, your work has to be original. Okay, if it's not original, you're not going to get copyright. 2, can it fit within one of the categories? And then the 3rd one is fixation. So fixation means, can you fix it? So if it's a book, if it's a written piece of work, your writing is the fixation, yeah? If it's a music, the recording, the sound recording is your fixation. And then if it's a film, the visual, the videography, that's your fixation. So as long as you can fix it, then you get copyright. If you can't fix it, you can't get copyright. It's not possible to have copyright in your head. You create the idea, you develop it, you express it, and then you get the copyright. Like the music we listen to or the films you watch, all of that is copyright. Now, the real issue comes in Section 9 of the Copyright Design and Patent Act and in all legislation is this idea of author. Who is the author of the work? Now, the author is a person who creates it, right? So that's easy. We're humans. We create copyright. We own it, yeah? Or you work for an employer. You as an employee are hired to create copyright, but your employer owns it. That's in your employment contract, right? So the issue then arises at the moment is, can AI, so can artificial intelligence own copyright? Can it be a person? So that's the question we're going to look at today. Over to you, Dennis.
Yeah, thank you. Ya, yang pertama tadi dikenalkan tentang kampus Universitas Aston yang ada di Birmingham. Kampusnya itu sebenarnya kampus yang bagus karena fokusnya itu lebih kepada bisnis dan perdagangan. Jadi orientasi kalau belajar hukum ya diorientasikan bagaimana nanti mempelajari terkait dengan hukum bisnis dan bagaimana perdagangan baik internasional maupun domestic trade sampai kepada bagaimana agar mahasiswa itu betul-betul memiliki jiwa usaha, jiwa untuk bisa melakukan menciptakan sesuatu. Itu yang ada di kampus Birmingham, dan dari kotanya juga sangat indah gitu ya. Ada museum, ada shopping center, kemudian ada juga kampus yang ada di sana. Dan tadi dijelaskan oleh Nadia bahwa Inggris itu menempati ranking 4 dalam indeks global inovasi global. Di belakang ranking 1 itu Amerika Serikat, ranking 2 itu Swiss, dan ranking 3 itu adalah Belanda. Dan ini menjadi salah satu negara yang bagus dalam hal haki. Kenapa? Karena untuk bisa masuk ke ranking 4 itu, maka Inggris harus memenuhi 80 indikator. Yang kesemua indikator itu bagaimana terkait dengan haki dan pengembangannya. Dan juga di Inggris yang salah satu hal yang paling penting, dan ini perkembangan yang kita sebagai mahasiswa UI harus paham, di Inggris sudah mulai tumbuh ilmu dan praktis terkait dengan Islamic Finance atau keuangan Islam. Saat ini sudah ada bank online Islam yang berbasis di Inggris. Jadi sekarang yang punya bank Islam tidak hanya negara Muslim, tetapi juga negara-negara non-Muslim. Kemudian tadi disebutkan bahwa macam-macam haki itu ada 2. Yang pertama adalah hak yang harus didaftarkan dan hak yang tidak perlu pendaftaran, karena itu otomatis begitu sudah menciptakan sesuatu, maka itu adalah hak kekayaan intelektualnya, perlindungannya adalah otomatis. Kalau yang hak perlu didaftarkan itu seperti paten, kemudian merek, sedangkan kalau yang tidak perlu didaftarkan itu seperti salah satu contohnya adalah hak cipta. Dan di internasional kita memiliki yang namanya WIPO. WIPO adalah organisasi internasional khususnya untuk bisa menangani terkait dengan hak kekayaan intelektual. Dan WIPO itu ada aturan dan standar, di mana WIPO ini memiliki beberapa aturan-aturan. Aturan-aturan ini sebenarnya untuk menstandarisasi, mengharmonisasi aturan-aturan negara-negara yang ada di dunia, khususnya untuk memberikan perlindungan terhadap kekayaan intelektual. Seperti dalam hak cipta, itu perlindungannya saat ini semua negara juga hampir sama, dan itu menganut dari apa yang diatur di dalam WIPO, yaitu diberikan seumur hidup kepada penciptanya, ditambahi 70 tahun. Itu kalau untuk hak cipta. Dan di Inggris mereka punya CDPA atau Copyright Designs, jadi hak cipta, undang-undang tentang hak cipta, desain industri dan paten yang dibuat di tahun 1982. Jadi 88, hampir sama dengan kita. Dan syarat untuk bisa, ini yang pertama tentang hak cipta, syarat untuk bisa mendapatkan hak cipta itu ada 3. Yang pertama harus dibuktikan orisinalitasnya. Harus ada pembeda antara satu dengan yang lain. Yang kedua harus memenuhi kategori sebagai barang, produk, atau sesuatu yang bisa diberikan hak cipta. Seperti misalnya musik atau art products atau barang-barang benda seni. Kemudian ada apa tadi ya, banyak sekali rekaman suara, program televisi, dan lain sebagainya. Dan yang syarat ketiga itu adalah fixation. Fixation itu artinya bahwa produk atau barang itu harus bisa berwujud. Dan misalnya kalau misalnya bentuknya film, ya harus bisa dilihat secara visual. Kalau bentuknya musik, lagu, MP3 atau MP4, maka harus dalam bentuk suara. Dan kalau misalnya lukisan, itu harus dalam bentuk gambar 2 dimensi. Nah, dengan syarat 3 itu, maka seseorang itu bisa mendapatkan hak cipta tanpa perlu ada pendaftaran. Itu automatic without any registration. Dan siapa pencipta itu menurut pasal 9 itu adalah orang yang memiliki kemampuan untuk menciptakan, yang memenuhi 3 syarat itu tadi. You may continue.
Thank you. So we're going to focus on this idea of authorship. Who is the author of the work? What does it mean to be the person who creates it? Okay, so let's have a look at this. So what do we understand to be artificial intelligence? So the the godfather of artificial intelligence is Marvin Minsky. He invented artificial intelligence. He was from MIT. And he said, AI is the science of making machines do things that will require intelligence if done by men. He forgot to mention women, but we will add that. So if done by men and women. And then we have David Fogel from IEEE Press, and that is the evolutionary computation towards machine intelligence. And he said, artificial intelligence is the study of intelligent behavior. Its ultimate goal is a theory of intelligence and accounts for the behavior of naturally occurring intelligence entities, and that guides the creation of artificial entities capable of intelligent behavior. Okay, then we come on to Wayman Rogers from 2020, and this is our most up to date. We have 3 categories of AI. We have narrow, general, and super. Narrow, we all know. So narrow is like AI assisted. It's cognitive intelligence. It's not conscious. So it's not driven by emotions the way we are, and it's down to very, very simple decisions. So for example, TurboTax is used by accountants, and that you put in specific criteria into the AI and it gives you the accounting. So very, very narrow AI. Then what we see a lot of now, which is general AI. So this represents some display of human intelligence that is able to perform some human tasks in terms of decision making. So if you use Spotify, for example, which is like a music app, it finds music that it thinks you like based on your choices. So it's thinking, it's like, you like Ed Sheeran, you like Adele, right? I'm going to find you similar music for that genre. So that's general AI because it's already thinking for you. On Netflix, you watch a few series on Netflix, all of a sudden recommended for you. Yeah. And they go, oh, Netflix knows me so well. It doesn't. AI knows you so well. And that's all in our lives. General AI, our phone, Siri, Google Maps, everything. There's so many recommendations. Sometimes it's like your phone is listening to you. You'll be talking about, oh, I need a new coat, I need new shoes. And then you get adverts for shoes, right? It happens, okay? So AI, general AI, is influencing our life and we don't realize. Now, the question is around super AI. So super AI displays features of all kinds of competencies, such as emotional and social intelligence, and is able to be self-conscious and self-aware in their interactions with others, right? So as humans, we are self-conscious. We are self-aware most of the time. So AI, if AI can be self-conscious, what is the difference between a human creator and an artificial intelligence creator? That is the big question, right? So we know where we are. We're past narrow AI. Narrow AI is very, very simple AI. That was 50, 60 years ago. Now, a lot of AI is general. We're getting close to super AI. We're getting close to this AI system. So WIPO has looked at this, which I will discuss because it's really important. So what WIPO has done is issued a paper on intellectual property policy and artificial intelligence. This is all very new because it's happening in these, like, since COVID, the AI had a chance to do even more work because everybody was indoors. So what it is looking at 2 key areas, okay? We have AI assisted, which is AI as a tool. So when you think about music, songs being created, there's AI tools, films, medicine, there's all of these AI tools that are assisting, and they can get copyright patent protection. Then there's AI generated. So that's when the AI tool is not assisting, but it's doing everything itself. At the moment, AI generated is not protected by IP, right? Because it says that AI generated is used to refer to the generation of an output by an AI without human intervention, right? That's big. So you tell the AI to create a song, but you tell the AI, I want the song in classical music, or I want the song in pop music, and I want the song to sound like a man, I want the song to sound like a woman. You give all of these instructions, the AI generates music, You edit, you check, and then you have music. You have the intellectual property because you edit it, right? The AI is a tool. It's like a recorder or any kind of sophisticated tool that you can use to create. It's assisting. But when it's generating the music without you asking it to do anything, who should the copyright belong to? There's no human author that can belong to. Or does it belong to the AI company that designed the AI? So you've got these issues around who the authorship can belong to. So what you then have is that the AI systems and their advanced development are reshaping the whole creative and innovative sectors that are protecting existing intellectual property systems. So it's necessary to identify the AI systems and map the direction of AI development. You can't stop AI development. AI is developing very, very fast. And it will happen that AI is going to be at a level where it doesn't need human intervention. So the question is, how do we, as the intelligent humans, interact with AI? How do we control AI, right? Because we don't want AI to control us. A little bit it does. You know, like on your phone when it keeps giving you ideas like, oh, but generally we want to be in charge, right? We don't want to be controlled by the AI. So WIPO has led a series of conversations and discussions in AI and intellectual property policy, the WIPO Conversation on Intellectual Property and Frontier Technologies. They also have the WIPO Young Academy program, which I really recommend you have a look at because they have lots of opportunities for international young students to learn about WIPO Academy and what they do. And this is one of the key areas for frontier technologies. So it's AI, it's emerging tech, it's data, robotics, privacy. All of these issues are very current at the moment. So what they're trying to clarify is what is the definition of AI supported, which is the very basic AI, AI assisted, which is what we have now, and AI generated. So beyond rule-based AI, and definitely looking at more sophisticated AI. So can AI embrace learning? That's the first one. Can it perceive? Can it abstract? So can it abstract the information? And can it reason? You've got 4 criteria that they are looking at for AI. So in this case, humans are authors and inventors of AI-supported outputs because the outputs are completely resulted from humans' full intervention, and therefore they own the intellectual property right with AI assisted. Yeah.
Yeah, I'm so interested on this. Okay, good. Jadi saat ini sudah ada teknologi yang namanya kecerdasan buatan. Siapa sih pencipta dari kecerdasan buatan? Itu adalah salah satu profesor yang ada di Massachusetts, itu di MIT, di Amerika Serikat, namanya Marvin Minsky. Dia mengatakan bahwa kecerdasan buatan itu adalah kemampuan teknologi untuk melakukan mengubah, mencipta, mendesain gitu ya, secara mandiri tanpa campur tangan manusia, dan dilakukan oleh teknologi itu sendiri. Dan ada beberapa macam dari kecerdasan buatan, begitu di slide tadi. Ada kecerdasan buatan yang bisa dikatakan sebagai narrow AI, atau saya nggak tahu ya itu bahasa Indonesianya apa gitu ya, tapi kan kalau diterjemahkan tadi itu adalah kecerdasan buatan yang sangat-sangat simpel sekali. Misalnya saudara punya Excel, saudara punya apa itu yang kalkulator gitu ya, saudara mengetik 500 ditambah 20 langsung bisa muncul 520 tanpa kita menggunakan otak kita untuk menghitung gitu ya. Itu adalah kecerdasan buatan yang masih sangat simpel sekali. Kemudian ada juga kecerdasan buatan yang masuk dalam kategori general AI, di mana untuk general AI ini itu dia sudah bisa mengerjakan tugas-tugas manusia. Jadi kecerdasan buatannya sudah sangat canggih sekali, tidak hanya kemudian melakukan hitung-hitungan sederhana, tetapi misalnya seperti saudara punya Netflix, saudara tidak pernah tahu nih atau saudara punya Facebook aja lah, bisa, atau Instagram gitu ya, sukanya nonton baju-baju gamis gitu ya, tiba-tiba muncul itu di reel, tiba-tiba saya nggak pernah ngecek baju gamis kok tiba-tiba baju gamis muncul semua gitu kan, atau lagi nyariin suami peci kok tiba-tiba peci baju koko muncul semua. Itulah kecerdasan buatan yang sudah general gitu. Dan tadi dan yang ketiga itu ada lagi super AI atau kecerdasan buatan super. Itu apa? Karena dia sudah, kalau yang general AI itu tadi masih ada apa istilahnya intervensi dari manusia. Tetapi kalau super AI dia sudah bisa membuat keputusan sendiri. Jadi dia sudah punya emotions, dia sudah punya critical thinking, termasuk juga social intelligence gitu ya. Kalau critical thinking, I don't think so. AI have this ya, only social intelligence, kemudian emotional, dia punya itu. Dan WIPO saat ini karena memang aturannya belum ada, perkembangannya baru muncul akhir-akhir ini, WIPO membuat paper atau laporan begitu WIPO tentang perlindungan haki dan juga perlindungan hak kekayaan intelektual dan kecerdasan buatan, di mana di dalam paper tersebut disebutkan kalau itu AI generated, jadi kalau ada produk yang dia dikeluarkan oleh AI generated, maka itu AI generated itu ya dia mampu menciptakan itu sendiri, produk itu sendiri, maka tidak perlu ada haki. Tapi kalau kecerdasan buatan itu dia menciptakan produk tapi masih ada campur tangan manusia atau AI assisted, itu maka dia membutuhkan produk itu bisa dibebani atau diberikan hak kekayaan intelektual. Dan sistem kecerdasan buatan sudah sangat pesat sekali, kata Nadia tadi, bahkan sampai sekarang kita bisa perlu untuk mengatur bagaimana cara kita berinteraksi dengan dia, apakah mereka yang mengkontrol kita atau kita yang mengkontrol, dan lain sebagainya. You may continue.
So AI has positive and negative impact, okay? Don't worry, he's not on fire. He's a stuntman. And he has shown the value of stuntmen, so he's faked fire. And actors in the United States are striking over AI. There's a big strike going on because artificial intelligence using streaming platforms and facial recognition can use an actor's face, and using AI can do an entire film, right? So the actors are striking because they're saying AI is going to replace them. So you remember all the movies about robots invading and taking over the world and killing all the humans, right? Very sci-fi, science fiction. Now AI is definitely advancing in certain industries where they can use an image and do an entire movie, do whatever they need. So the actors are striking because they're saying that they have no work. This is going to impact their work. Their streaming revenues are very, very low for American prices, and they have doing a big strike against AI. Now, not all AI is bad, right? AI can be good as well. So the question is, AI can enhance or AI can replace. So which one do we want, right? So we want the enhancement, but we don't want AI to replace humans, right? That would be silly, okay? So thinking about the impact of AI on all industries. So we've got to remember AI isn't just for actors, it isn't just for music, it's healthcare, it's lecturers. You can have an AI academic, you can have an image of an academic that you'd like, you'll get a hologram, and you can have a lecture without anybody present, right? Yeah, that's a lot of yeses. I'm worried now. But yes, yeah, you can. So AI enhance, that could be great, right? But if it's replacing, yeah, we need to think about that. So let's think about artificial intelligence on a global level. So European Parliament have been looking at this since 2017. The other thing to bear in mind is AI is new. So no one country has 100 years advantage on AI. Everybody is considering AI at the same time. So what the European Parliament did, it passed a resolution on the 16th of February 2017 with recommendations on the commission of a civil law rule on robotics. So at the moment, the EU is looking at an AI Act, right? to make law about what is legal and not legal around AI. The UK is doing the same thing. So there's a lot of development in this area. So the question is, what is an effective intellectual property system that safeguards innovation and creation where AI applications are involved? Because intellectual property is all about innovation, right? It is meant to make our life easier. So we have inventions, we have creations, you know, we have laptops, we have washing machines, we have cars, and now we're going to get autonomous cars, right? So cars without drivers. Feel comfortable sitting in a car without a driver? No? Good. Because the one in America knocked somebody over. It has sensors and it's a driverless car. So it didn't pick up that there somebody was crossing. So the car hit it. What about an aeroplane without a pilot? Autonomous. Yeah, it's happening, right? All of these things are happening. So you'll remember me when you sit in an airplane without a pilot. And you, Nadia said, you remember, you're like, oh, she was right. So the European Parliament passed a resolution in 2020 on intellectual property rights, developments of artificial intelligence technology. So this is all happening as we're speaking. So they've proposed the first ever legal framework on AI, which addresses the risk of AI and positions Europe to play a leading role globally. Now, by risk, I mean ethics and trustworthy AI, because AI has a lot of bias, okay? So AI can only generate based on the input, right? So if you put in intellectual property law lecturer into the AI system, you will get a 50-year-old white man. You won't get me, because the system is biased, right? I am the intellectual property expert, but the system doesn't know that. So they have to complete law which removes bias. How do you remove bias and the risk of AI, right? So what the MEPs did, these are members of the European Parliament, they proposed to address long-term opportunities and legal challenges posed by AI. That's on ethics, civil liability, and intellectual property. So currently, there's no uniform contractual clauses used by all or most AI service providers. Now, in IP, and I always say this, contract law is your basis. You should be experts on contract law because that is your foundation to intellectual property law or any area of law, because you need to be able to draft, you need to be able to analyze, and you need to be able to amend existing legislation. So what the Commission report states is that the EU global leadership in AI requires an effective system, right? So what is inventorship? And at the moment, the EU is saying inventorship should only be granted to humans, right? Not to AI, because they're saying the technology isn't there yet. That doesn't mean the technology won't be there soon, right? So that's the issue. When it will be, I can't tell you. So don't ask me that question. I don't know the answer as to when, but what I can say to you is it will happen soon. So let's look at copyright, because in patents, you'll have heard of the Dabas case. If I have time, I'll come on to it. But it's pretty much straightforward in patents. In patents, you have to be a human inventor. If the AI is assisting you, then you come to a contractual deal with the AI company where you give them a commission or you pay them an extra fee, but they don't get intellectual property rights. You as the patent holder, you get 20 years monopoly. Now, thinking about like the most expensive patents in the world, like in the thousands of pounds or dollars, your patent can generate a lot of revenue for you. Even the iPhone, right? Everyone has an iPhone or a Samsung, like the latest phone. The amount iPhone make is a fortune. You're not paying for a brick, right? Nobody pays a lot of money for plastic, right? Plastic is cheap. The value is in the patents, it's in the software, it's in the Siri, your Google Maps, your music downloads. That's where your value is. That's what you're paying for, right? So what they need to look at is in patents, what the law is saying at the moment is that it has to be a human. It cannot be a non-human. So the Dabas case was by a guy called Stephen Thaler, and he wanted to give AI ownership to Dabus. So Dabus is the AI, right? But the problem then is Dabus isn't human. So what Thala was saying, Dabus is the AI creator. I own Dabus. Dabus transfers his patent to me, the human. But the court is saying, if Dabus can't own a patent, how can he transfer it? Or it? I am assuming Dabus is a he. I'm not saying he's a he. But how does Dabus, the AI, transfer ownership to a human? Where's the consent, right? So there's lots of issues with that. But let's look at copyright first of all. So there has been a lot of evolution in copyright. So the tradition of copyright in music is that you create the music, CDs, cassettes, you're all very young, but your mom and dad might have some cassettes players. So, and then you get the radio music coming out. The revolution is the AI. So that middle part of creating now done by the AI. So what does AI have to offer music producers? Is it a boon or is it a threat to how music is made for a living? So we know from the strikes, it's a threat to the living, but then also, how do you create without it? So we know the author is the person who creates it. We know that there needs to be skill, labor, and judgment in copyright. Yes. So you have to have some skill, some labor, some judgment that you have put in to create your copyright. You can't like magically create copyright and claim it. You have to have some skill. So a copyright work has to be created with a human by some assistance. Now in the UK, we have something that's known as computer generated works. And this is AI created. And this gives you 50 years of protection, but it's only databases. So it's not music, it's not patents, it's not books, it's only for databases. So the distinction between when there is human involvement needs to be more clear in copyright. So what do we have? So we have the EU has been working on this, and the idea expression dichotomy at the top is the traditional human idea expression output, right? Now what we have is conception. Conception is your human. So you will say to the AI, produce the next best rock music in the world, right? Now the execution is the AI. So the AI will go through all of its tools and come up with lots of different ideas for what is the best music, rock music in the world. Then redaction. This is where the human comes back in and the human says, oh, no, this is not so good. Scrap that, put that in, change this, and then you get the output. Okay. Now that is okay for copyright. As long as the conception and the redaction is human, you can have copyright. Yeah. So what you have is conception, that's your design and specification, execution, producing draft versions, and the redaction is your editing finalization. So AI is dominant at the execution phase, and the role of the human author is at the conception stage, and that's essential, right? So where the human is in charge of redaction, then there's even more opportunity for it to be copyright protected. But if the AI system is automatically executing content without the output being conceived or redacted by a person, there will be no work. Okay? So yes, AI can produce music, but it's not copyrightable. Okay? Should you want me to stop there for a second? Yeah.
I think you need to have an example on Pfizer. Okay, good. I got a lot of impression on this. Oke, jadi tadi ada gambar mana orang-orang pada sedang demo kan, bakar-bakaran itu tadi. Karena apa? Di Eropa dan di Amerika Serikat sudah terjadi bahwa keberadaan kecerdasan buatan itu justru malah menciptakan mereka tidak bisa mendapatkan pekerjaan. Jadi harus berhati-hati nih yang mau bercita-cita jadi notaris, menjadi penyanyi, menjadi apapun itu sekarang, apalagi dosen, sebentar lagi akan digantikan dengan teknologi yang namanya kecerdasan buatan. Sehingga kemudian terjadilah suatu timbul pertanyaan bagi kita, hadirnya kecerdasan buatan itu apakah untuk dalam rangka pengembangan teknologi informasi atau dalam rangka untuk menggantikan peran-peran manusia. Itulah yang saat ini dibahas terus-menerus oleh para pakar hukum. Sehingga kemudian tadi banyak dijelaskan tadi kecerdasan buatan sudah semakin banyak sekali digunakan. Kita bisa menciptakan musik, kita bisa menulis paper, bahkan katanya tadi sudah mulai muncul sekarang artificial intelligence, kecerdasan buatan yang menggantikan dosen untuk mengajar. Jadi kalau teman-teman bosan gitu ya, dengerin saya kuliah gitu, sudah ada hologram atau videonya gitu ya, mau dirubah wajahnya jadi Justin Bieber, maybe you can ask. I told them that maybe the artificial intelligence can change my video visual presentation to be Justin Bieber, or maybe the man's favorite here, Lunta Luna maybe gitu ya. Biar lebih masuk gitu ya ilmunya. Ya itu sudah kecanggihannya sudah sangat luar biasa sehingga kemudian di Eropa itu ya kalau hari ini kita sibuk Pak politik 2024, di Eropa itu sudah rapat berkali-kali dan di tahun 2020 mereka sudah membuat yang namanya resolusi Parlemen Eropa untuk menjawab khususnya isu-isu dalam bidang kecerdasan buatan. Di mana di situ mereka merekomendasikan perlu ada pengakhiran atau memastikan bahwa di dalam kecerdasan buatan itu kan ada proses yang bias yang semu yang kita tidak pernah tahu apakah itu dikerjakan oleh manusia atau tidak. Yang hal-hal yang bias itu perlu dijawab oleh para pakar hukum atau Komisi Uni Eropa atau lembaga yang ada di Uni Eropa. Hal-hal yang bias itu salah satunya terkait masalah etika. Kemudian yang kedua tentang pertanggungjawaban perdata, dan yang ketiga khususnya terkait dengan hak kekayaan intelektual. Tadi Nadia juga sudah mengatakan bahwa bisa jadi loh kita itu membuat hak cipta, tapi itu ada pengaruh karena dibantu oleh kecerdasan buatan. Tadi disebutkan bahwa seperti Dalmas is a kind of what is the Dalmas thing? Bus ya?
Autonomous device, bootstrapping. It is AI basically.
Mm-hmm.
That's the acronym for the long name.
Mm-hmm.
So
it's copyright, right? The name.
Davos is not copyright. That's
patent. The acronym. Long name. What is the product about? What is the product about?
The product. So his AI invention he hasn't revealed. That's
okay. Ya. Oke, jadi ini ada kecerdasan buatan yang namanya Dabas, begitu ya, dia bisa menciptakan sesuatu dan orang yang menerima paten orang yang menerima produk yang dia minta kecerdasan buatan untuk dibuatkan itu, kemudian meminta agar ada proses transfer paten dari si Dabas kepada orang manusianya. Nah, sekarang pertanyaan, lah, wong ini aja Dabas itu adalah kecerdasan buatan, bukan manusia, bagaimana dia bisa memindahkan paten begitu ya dari teknologi ke manusia kan? Kita belum sampai ke sana begitu ya tadi disampaikan itu ya, belum sampai teknologi itu bisa dilakukan secara mandiri seperti itu, sehingga kemudian perlu dibutuhkan banyak pengembangan. Salah satunya tadi disebutkan di sini bagaimana aplikasinya dalam hak cipta misalnya. Ternyata dalam membuat hak cipta yang selama itu ada pengaruh atau role atau peran-peran manusia dalam menciptakan karya-karya cipta itu, insya Allah itu bisa dihakikan. Makanya ada 3 syarat agar bisa dihakikan ketika kita meminta kecerdasan buatan untuk menciptakan sesuatu, maka harus ada 3 kategori yang harus dipenuhi. Yang pertama adalah conception, bagaimana peran-peran kita untuk memerintah kecerdasan buatan itu untuk melakukan sesuatu, kemudian eksekusi, proses produksinya, kemudian yang ketiga reduction. Reduction itu proses finalisasi. Misalnya saya minta Siri saya gitu kan, tolong saya dibuatkan musik musiknya romantik gitu ya, terus membuatkan sendiri musik itu kepada saya begitu ya. Tapi kan tidak kemudian serta-merta musik itu menjadi bagus. Kalau saya kemudian ikut merubah, ikut merancang, ikut menjadi finishingnya menjadi bagus atau melo atau seperti apa atau agak dangdut sedikit misalnya gitu, maka disitulah saya bisa hasil dari karya saya yang saya ciptakan dengan kecerdasan buatan itu bisa saya berikan hak kekayaan intelektual.
So we have waves of AI. So the first wave, handcrafted knowledge. We know that's AI supported, material human intervention. Second wave, statistical learning. So this is shared contribution, AI assisted. And the third wave, contextual adaptation, non-human intervention. And then can there be a fourth wave? This is the big question. So can there be a further wave of AI? There will be. I think for definite there will be. The fundamentals, you have originality, human authors, and you fix it. So we have the Berne Convention for the Protection of Literary Artistic Works. The EU has the Software Directive and Database Directive. The UK, we have the Copyright Design and Patent Act. And in the US, register an original work of authorship, provided the work was created by a human being. So the US even state human being, not person, human being, right? So existing copyright system, the author has made free and creative choices and their work has their personal touch. So if there's a new law for artificial intelligence, how does artificial intelligence have a personal touch? Or how does it create freely if it's an AI system, right? So a lot of interesting work has happened in this area. So let me show you. So this is the next Rembrandt. So Rembrandt is a very famous painter from the Renaissance period. So his real focus was the eyes. So the picture here is a Rembrandt, and he does a lot of colors and eyes. The picture at the top is another Rembrandt. My apologies, I couldn't get a clearer one, but you can look him up. And then here is where they asked an AI tool to the eyes, the mouth, the nose, all of the key Rembrandt features, right? So what this company did is that they instructed by a company to create the next Rembrandt. Okay. And then what they did is they put all of Rembrandt's paintings, 367 paintings or something like that, into the AI tool and said, create the next Rembrandt. So remember, going back to what I was saying, area, conception, redaction, execution, all of those phases. So the conception was the company. The execution was the AI. So it used all of these images to create the next Rembrandt. And then the redaction was then the company again making more changes. And then they got the next Rembrandt. The issue was, who owns the copyright? All the work was done from the AI, right? So you could have a fortune painting and you didn't even wet your paintbrush, right? It was like, click, click. Make me a painting, okay? So the courts looked at this and they were saying the aim of the work was not to create a specific painting, but to utilize artificial intelligence systems to the disposal of the creative team and create a simulation. So this was Walter Thompson Agency in Amsterdam, and they commissioned this painting. They used Deep Dream Generator and Google for surreal photographs. So the goal was to discover an algorithm that could create a physical work of art that looked like a genuine Rembrandt painting. So they had data scientists, engineers, art historians, over 300 Rembrandt paintings, his techniques, his style, his subject matter, digitally rendered graphics, all of this to create the next Rembrandt. So they said the step one was human, right? The step one to make the instruction was from a human. The step two, the artwork has to demonstrate that it's the product of human effort, which would be the experts and team. And then focusing on step three, we know that AI can support the creative process and that the originality test is met by a human. So the next Rembrandt got copyright protection. Lifetime plus 70 years. There you go. But it's not always like that. So this is my favorite non-human in the world. The monkey selfie. The next time you take a selfie, remember, a monkey can do that. Yeah? So cool. So cool. So what happened? The monkey takes a selfie. Oh, it's so awesome. And PETA, which is like the protection of animals in America, said the copyright should belong to the monkey. Yeah. So America has a very clear system. They have the Compendium of US Copyright Practice. And in their law, they say that only a human can own copyright, not a monkey and not a machine, right? So in the same category as AI is a monkey, which I think is unfair to the AI because I love monkeys, but AI is very, very more sophisticated than monkeys, right? So to have AI as a non-human actor, it has to satisfy the originality test. Is it original that the monkey took a selfie? I think so. But the issue is there's no law, right, that allows non-human actors to take copyright. Now, the monkey thing was a fluke, right? It was a massive coincidence, just luck, right? Very lucky. But AI isn't about luck. AI is about using computers and computational systems to come up with actual copyrightable material. So thinking about the legal challenges in authorship, right? So the question is, copyright protection requires a specific and creative input by a person that sufficiently determines the artwork. In the case of AI, media of any kind can produce very small data input. So text to image, text to video, large language models. So legal uncertainty as to who is considered the author of the produced metadata in terms of the program. And the UK law has attempted to look at this through arrangements for the creation of the work. So to determine this, we need to look at what level of complexity takes place in the AI and how much does it rely on random elements to get from few data points to a complex data arrangement. So the outputs to text image models, such as DALL-E 2 and Midjourney, is in the public domain. Have you all heard of DALL-E 2? No? Yeah? DALL-E 2 is an AI system and it generates non-copyrightable material because it's in the public domain. Let me show you how it works. So you put into DALL-E teddy bears working on new AI research on the moon in the 1980s. Pretty good, right? You got teddy bears, you've got 1980s computers, and they're on the moon. You just type, just type, you put the apostrophes in, you stick that into DALL-E 2, and that's what you get. It's pretty good. It's pretty good, right? So the question is, how does this work? So let me give you a very brief, I'm going to be out of time, so I'm going to try and be as quick as I can. So you put in the text prompt, teddy bears working on new AI research on the moon in the 1980s. That goes to your CLIP algorithm and text embedding. Remember, all code is 10, 100, 10110. That's code. That is AI. So we think of AI as this, like, you know, Sophia the robot in Saudi Arabia, like super sophisticated. But really, all AI is code, right? Then it decodes it, it embeds the image, and it gives you your algorithm. And that produces the teddy bear picture. So that's how DALL-E 2 works as a structure. And then you get the teddy bear. So in the case of DALL-E 2, no individual person has sufficient control or foreseeability for the algorithms to be considered an author. So this is not copyrightable, right? Because every time you put that into the DALL-E system, you'll get that picture. So you can't copyright it. Yeah? But very, very interesting in terms of what's going on. So what you need to think about is the public domain output lead to novel changes. So what is the burden of proof? A potential infringer might claim a specific piece of media in the public domain by claiming it was AI generated. So proving a creative process significantly involves a human creator might be difficult. especially for images or photographs. So defining contractual relationships. Without copyright protection, the generated product is just data. As of now, no legal ownership of data in most jurisdictions. So the contract has to focus on the service provided. So again, this is where your contract law comes in. So let me just do some key takeaways because I know I'm out of time. No, I don't have time to do that one. That's another time. Okay, so key takeaways. So understanding the specific technological background of any AI is paramount for providing legal advice, which is what you guys can do in the future as IP lawyers. Ownership of AI generated content requires sufficient control and foreseeability of the technology. So it's necessary to implement guidelines for the use of AI generated content and protection measures against public domain defenses and IP litigation. So contract drafting, agreements, all of these include the application of AI systems, which requires a detailed description of the technology involved and the services provided. So there is a phenomenal opportunity as aspiring lawyers to look at AI and how that impacts contract law, intellectual property law, and it will give you such a good competitive edge in the working environment. I'll stop there.
Yeah, another 5 minutes, I think is fine. Okay. Just to summarize the pattern things. I saw the doll. Yeah, maybe after I translate. So, jadi tadi sudah disebutkan bahwa sudah banyak tantangan-tantangan begitu ya. Kemudian tadi seperti tadi disebutkan bahwa hal yang sangat fundamental untuk bisa kita pahami ketika kita menghadapi apakah suatu karya itu bisa dihak ciptakan atau tidak, ketika karya itu ada pengaruhnya dari kecerdasan buatan, maka yang tadi harus dicek orisinalitasnya, yang kedua peran dari manusia atau orang yang mencipta dari karya tersebut. Makanya tadi disebutkan itu juga fundamental sekali dan itu diatur dalam Berne Convention. Dan kemudian itu tadi ada contoh gitu ya, lukisannya Rembrandt itu sangat terkenal sekali dan mahal sekali karena Rembrandt ini adalah pelukis terkenal di zaman Renaissance. Dan kemudian ketika lukisan Rembrandt ini dimasukkan ke kecerdasan buatan, maka kecerdasan buatan itu bisa mengukur, bisa melihat, bisa mengidentifikasi, bisa menginvestigasi setiap guratan-guratan lukisan yang ada di dalam lukisan Rembrandt tersebut. Sehingga kemudian kita bisa memerintah, dan pernah ada yang membuat kecerdasan buatan yang kita memerintah agar kecerdasan buatan itu bisa membuat lukisan the next Rembrandt, lukisan-lukisan lain Rembrandt yang hampir sama. Dan ternyata kecerdasan buatan bisa menciptakan kurang lebih 370 lukisan dalam waktu yang sangat cepat, dan ini menjadi suatu pertanyaan, kira-kira apakah bisa 370 lukisan itu kemudian dihak ciptakan. Makanya kemudian perlu ada suatu kesimpulan bahwa apakah mesin, apakah binatang bahkan gitu ya, dengan logika tadi pakai menggunakan monyet bisa selfie itu, apakah kalau monyet itu bisa selfie begitu ya, itu kemudian monyetnya itu bisa mendaftarkan hak ciptanya gitu ya. Saya juga nggak tahu bagaimana lawyernya itu bisa berkomunikasi dengan monyetnya itu gitu ya. Nah, tetapi perlu, makanya apakah perlu kita samakan bahwa mesin dan monyet itu sebenarnya tidak bisa mendaftarkan hak cipta atau melakukan transfer dari hak cipta dari satu orang, dari mesin atau dari monyet kepada manusia. Sehingga kemudian, dan juga tadi kalau yang monyet tadi ada juga pihak yang membantah kalau monyet tadi itu bisa selfie senyum seperti itu sebenarnya adalah keberuntungan, faktor keberuntungan. Kebetulan saja dari ribuan monyet yang ada, jutaan foto yang ada satu yang kebetulan pas banget, dia pas lagi senyum. Sebenarnya nggak tahu ya itu lagi senyum apa enggak, dan kemudian pas juga seperti itu. Jadi tidak juga bisa disamakan antara monyet dengan mesin. Nah, sehingga kemudian banyak sekali tantangan-tantangan hukum dalam hak cipta, dan khususnya tadi ada juga salah satu aturan hukum yang sudah mengatakan bahwa yang seperti tadi kalau kita memasukkan di deal A, ada deal A2 atau apa tadi, ada aplikasi ya, bukan aplikasi, jadi kalau kalian searching di Google itu ada softwarenya begitu ya. Kalau kita menulis misalnya tadi beruang sedang bekerja dengan kecerdasan intelektual di bulan pada tahun 1980, kita mengetik kalimat itu langsung bisa dibuatkan foto. fotonya langsung ada beruangnya, ada komputer tahun 80, mereka sedang lagi di bulan dan lain sebagainya. Nah, itu termasuk yang sudah disepakati oleh ahli yang ada di Amerika Serikat, itu termasuk yang tidak bisa diminta untuk mendapatkan hak cipta. Sehingga tadi perlu banyak elaborasi, pedoman, khususnya bagaimana cara pembuktiannya, hubungan kontraktualnya, kemudian deskripsi dari masing-masing ciptaan itu harus detail. Maka seorang audit dari HAKI itu sangat detail untuk memastikan bahwa itu ada peran tangan manusia, sampai kemudian perlunya adanya pedoman dan perlunya pemahaman yang komprehensif. Orang hukum ternyata hari ini saya pun juga merasa ilmu saya berkurang, bukan berkurang, ilmu saya kurang untuk memahami perkembangan teknologi itu tadi. Karena untuk bisa memahami hukumnya, untuk menciptakan hukumnya, untuk memberikan pendapat hukumnya, kita harus tahu betul. Dan tadi disebutkan itu saja bisa buat beruang itu kan logaritmanya panjang sekali. Yang kita tidak pernah tahu prosesnya seperti apa. Belajar matematika sin kostan saja ngantuk di kelas, apalagi mau belajar logaritma begitu ya. Itu saja. I think you have another 5 minutes.
Okay,
then we will have.
Okay. So thinking about patents. So patents are something that is different from anything ever done before, anywhere, at any time. So can you check to see if the patent is novel? That is your first step. So you can look at many sources, as you can look in the internet, on databases like Espacenet. And what you do is you need to check if invention is not already there. So you've got a great idea, you've got a great invention, but somebody has already filed a patent. That means they're ahead of you. If somebody files a patent, then you cannot file the same patent. So you've got to think about what is novel. Now, it's hard to think of something completely novel because almost everything is invented that we can think of. So what you also have is incremental developments. So you could develop something that is the next laptop, the next phone, the next screen, the next watch. Yes, thank you. So you can do incremental developments, and you can then create the novelty around that. So either it can be completely new or it needs to be novel. Okay, that's your first step. The second step is inventive. So it must not be obvious to a person skilled in the art. So this means someone with good knowledge, experience of the subject. So if you present your invention to somebody who is skilled in the art and they look at your invention and they say, oh, that's obvious, you can't get a patent. It has to have an inventive step. So not all inventions are inventive, but the checking, so the person who checks your invention is not a creator. So they're not going to see the inventive side. They're just going to make sure that it is not obvious. Okay, so your patent has to have series steps. Now, to be a patent attorney, you need to have often science and law, because a lot of inventions are very technical and very scientific, and you have to give all of the drawings, all of the exact measurements of how it works, and then you get the patent. The third one is that it has to be capable of industrial application. So what you have here is a famous English phone box, but it's also known as Doctor Who. Now, Doctor Who, when he steps into the phone box, he is a time traveler. So the phone box is a massive time machine, okay? In reality, you can't make a time machine, okay? So as an invention, it fails. So capable of industrial application is really simple. Can it be made? Does it have a use? So not necessarily to show if it will work, but just that it's plausible. If your invention can't be made, you fail. You can't have an invention that is that complicated that nobody can make it, okay? The fourth criteria is excluded matter. So in all law, patent law has to have commercial value, but it cannot be immoral and it cannot be contrary to public policy. So what you then do is you have to check against all defenses and make sure your patent is not excluded. So if it satisfies those four criteria, what you then have is a potential to have a patent. You then apply. patent registration is very, very expensive. It's the most expensive of all IP rights. So in the UK, it's about £2,000, which is a lot of money for a patent. A trademark is £200. So 10 times more to get a patent. Very, very expensive. It takes a year and a half to get to the priority stage. After that, it takes a year or two to get the full patent. And then after priority, your 20 years start working. So you have 16, 17 years of the patent. So those are the 4 criteria. And then like I was talking to you guys earlier, the Dabas case, right? The AI inventor. So how does Dabas own an AI related invention? We know that patent has 4 steps: novelty, inventive, can it be made, excluded. So the first step, how does Dabas get the instruction to start the patent? So what happens here? So Thaler is the name of the guy who owns the AI. So it's his software. And in the UK, he applies for a patent and he says, I am not the inventor. Okay. He says the inventor is the Dabas system. So Dabas, the full name is, it's a device for the autonomous bootstrapping of unified sentience. Yeah. So that's why it's called Dabas. Okay. So Thaler owns the AI and is entitled to obtain the right to the granting of patents. So, put simply, Dabas is the inventor and Dabas is owned by Thaler, right? Due to the ownership of Dabas by Thaler, Dabas has transferred the right to grant the patent to Thaler. So, the issue is, can he do that? So, the question is, the decision of the IPO, so the UK IPO, when they looked at this, they said no. They said you can't have a patent because the first step of novelty, Dabas didn't do, right? Thaler had to instruct Dabas to then do the inventive step. But the first step fails because the first step is novelty, and that is the human inventor. So Dabas didn't stop there. He applied for a patent in Australia, in the US, he's applied for a patent in Saudi Arabia and also South Africa. Now, South Africa said yes, which is crazy because if the invention, they haven't fully revealed it, but it's about like a reheating, like a fast heating of something. So say you burn your hand, who do you sue? So there's a problem, right? South Africa saying yes is not a good idea. Everybody else has said no. And really the question is, how do you bring it to account? How do you sue an AI system for intellectual property infringement? How do you sue for patent infringement? So that's the main issue with this case. So at the moment, it's good that it's rejected. I don't know what South Africa are going to do. They're probably going to have to redact their decision. But every other country has rejected the AI inventor for now. And at the moment, it is all very, very sophisticated codes. And code can't be novel. So that's the patent issue at the moment with intellectual property.
Kita membahas tentang masalah paten gitu ya, bahwa untuk bisa mendapatkan paten maka harus dibuktikan bahwa karyanya itu betul-betul baru, punya novelty begitu ya. Dan seperti misalnya memang sangat susah sekali ya untuk menciptakan sesuatu hal yang baru karena sekarang semuanya sudah pada dipatenkan. Jangan-jangan nggak punya ide, sudah ada yang punya patennya seperti itu. Sehingga kemudian Nadia tadi menyampaikan bahwa mungkin bisa jadi paten itu terjadi karena adanya pola pikir kita yang mungkin mendasarkan pada perkembangan environmental, lingkungan. Misalnya kita sudah punya sekarang nih telepon seperti ini, terus tiba-tiba sekarang butuh telepon yang bisa dilipat. Sebentar lagi iPhone katanya bisa bikin telepon yang bisa digulung. Saya nggak tahu nanti setelah itu bisa didadar atau enggak gitu ya. Jadi the next iPhone is always changing gitu kan. The next technology is always changing. Dulu screen kok TV kan bisa kita lihat ya kotak besar sekali gitu ya. Terus agak ramping, terus ramping mulai tipis lagi seperti itu. Jadi orang pada menciptakan penemuan-penemuan terhadap hal-hal yang baru yang dibutuhkan oleh masyarakat saat ini. Sehingga hal ini menjadi sesuatu hal perkembangan yang menjadi sangat yang tidak normal dan bagaimana untuk mendapatkan paten, maka harus memenuhi beberapa langkah. Ada 4. Yang pertama itu adalah harus memenuhi langkah inventif. Jadi harus ada betul-betul proses bahwa ini ditemukan, adanya penemuan, proses penemuan seperti itu tadi, dan itu harus betul-betul obvious. Obvious itu betul-betul bisa terlihat begitu ya dari deskripsinya. Makanya kan setiap orang menciptakan paten itu kan dia harus bisa mendeskripsikan dari paten itu sendiri dalam bentuk laporan, bentuknya, gambarnya, susunan anatomi barangnya dan lain sebagainya. Kemudian syarat yang kedua itu adalah bisa diaplikasikan. Sehingga kalau misalnya kita punya bayangan tadi kan ada contoh Dr. Who. Dr. Who itu selalu pengen, kalau kita lihat itu kan dia pengen menciptakan kotak. Tadi telepon itu kan kalau di Inggris kan terkenal sekali ya kotak telepon itu. Kemudian kalau kita masuk kita bilang aku mau ke tahun 2030 gitu kan. Terus tiba-tiba bisa ke 2030. Itu kan sesuatu hal yang belum sampai hari ini belum bisa diaplikasikan. Masih awang-awang. Sehingga itu tidak bisa dipatenkan. Sehingga betul-betul harus bisa diaplikasikan dan itu sudah dalam bentuk suatu ciptaan atau produk seperti itu. Dan yang ketiga itu harus memenuhi hal-hal yang tidak dikecualikan atau excluded matter dan harus memiliki nilai komersial atau nilai bisnis. Makanya kita harus berhati-hati menciptakan paten, tetapi ternyata itu dilarang. Oleh pemerintah Indonesia. Misalnya, kok menciptakan paten teknologi membuat pil ekstasi misalnya gitu ya, atau menciptakan barang-barang yang mungkin dilarang oleh peraturan perundang-undangan itu dikecualikan, tidak diperbolehkan. Makanya tadi disebutkan Dabas tadi itu adalah kecerdasan buatan. Yang punya Dabas itu adalah namanya Tala. Nah, kemudian ketika Dabas diminta untuk menciptakan paten, pertanyaan menjadi apakah paten ini bisa ditransfer dari kecerdasan buatan kepada si Tala, pemilik kecerdasan buatan. Ini akan jadi masalah kalau misalnya kita berikan paten kepada si Dabas. Kenapa? Bisa nggak Dabas itu dibawa ke pengadilan? Ini kan menjadi pertanyaan. Yang mewakili pengadilan siapa? Yang akan menjelaskan siapa kan? Kecerdasan buatan punya keterbatasan sendiri. Sehingga kemudian tadi disampaikan di Amerika Serikat, di banyak negara, berdasarkan hasil riset yang dilakukan oleh Nadia, hampir semua sepakat bahwa kecerdasan buatan mereka tidak bisa mendapatkan hak atas paten. Begitu. That's all I think. Finally. Ya. Kita beri tepuk tangan. Ya. Ya. Semoga pekerjaan jadi Google Translator ini berjalan dengan baik. Dan bayarannya ditambah, Mbak Roma. Baik, terima kasih. Silahkan kalau ada pertanyaan. 1, 2. Dalam bahasa Indonesia jangan takut, silahkan. Saya akan terjemahkan. Mbak siapa lupa? Ini mahasiswa saya. Mbak Sulis ya, silahkan. Boleh. Mau pakai bahasa Prancis, Arab, silahkan. Saya bisa translate. Ya, silahkan. Ya, I will translate. Mm-mm. Mm-mm. Ya, ya. Mm-mm. Ya, ya.
Yang sangat kemudian baru-baru aja, baru-baru tahun ini. Sedangkan AI ini nanti akan memasuki seluruh lini, seluruh sisi dengan teknologi. Artinya masyarakat dipaksa untuk siap dan dipaksa untuk bisa. Nah, terkait dengan keseimbangan itu, yang nantinya akan muncul mungkin bisa dikatakan kapitalisme yang mana penguasa teknologi atau penguasa ilmu pengetahuan akan mencaplok ya istilahnya memonopoli dan mendesak kaum yang mungkin belum siap tersebut menjadi semakin termarginalkan. Nah, menurut saya mungkin apa seharusnya yang dilakukan pemerintah untuk melindungi itu? Sementara tadi disampaikan bahwa AI itu kan bisa bermanfaat dan bisa juga mengancam, ya kan?
Bermanfaat di sini jika syarat-syaratnya banyak sekali, jika kita bisa mengendalikan, jika kita bisa mentransform dan sebagainya. Tapi bagaimana jika tidak terjadi? Bagaimana jika manusia itu tidak mampu mengatasi AI itu sendiri? Sementara masyarakat berkembang dan kita nggak bisa masyarakat yang belum siap itu untuk menerima itu. Apa yang harus dilakukan? Mungkin dari kita, dari pemerintah, dari AI itu sendiri.
Ya.
Cara mengawasi dan mengendalikan itu harus dilakukan.
Ya, luar biasa. Terima kasih. I'll try to translate. It's long questions. I will make it simple. So, she said that there is a huge gap right now. So, the owner of the technology, the artificial intelligence, is a developed states. You, your state, and then America, and then Western countries, and then there is a huge gap. Just for example, Indonesia, or maybe small countries in Southeast Asia, or maybe in Africa, they do not have any ability to. They may be able to operate, but they're not able to create or maybe to utilize it to be more comprehensive and producing IP and so on. So then, with this huge gap, what are your recommendations? Because if you see that there will be a huge capitalism, so the owner of the technology will stay stronger, but then the developing countries or maybe poor countries will have no ability for that, and they will stay weaker and weak. So what do you think about that?
So I think it's really important to look at how you can develop your infrastructure and capacity building, human resources within the country, but it's difficult without the international level. So for example, the UK Intellectual Property Office is working with the Saudi Arabia Intellectual Property Office. So what it then does is knowledge exchange on IP, on artificial intelligence, and then also on the valuations. So Saudi Arabia operates on Islamic banking. So what the UK is doing is advising on intellectual property and Islamic finance, because we have the 4th Global Innovation Index for IP in the UK, and we're the biggest Islamic finance sector outside of the Gulf. So we have 2 areas that we can support on. So for Indonesia, it's the same thing. When you're talking about international collaboration between a bilateral agreement between Indonesia and the UK, Indonesia and the US, that's where at an international level, there has to be knowledge exchange. Because you're right, all of these companies are based in the UK, they're based in the US, they're based in Europe. There's no DABUS in Indonesia. So you're never going to have that level playing field without knowledge exchange. So at an international level, when bilateral agreements are made, there has to be a requirement for knowledge exchange. So infrastructure building, so that's learning, whether it's, so we have the Digital Transformation Center or Law and Technology Institute, and then it's training in those institutes. So whether it's the Indonesian government sponsors or part of the agreement, but then that Indonesians have to then get that learning as you guys, as the academics, the young next generation is then learning. And because we are now global, so there was a time where you couldn't go to another country and study. This hybrid learning, you could learn this in Indonesia using online tools and online learning systems. But it's a really big question because the gap is getting bigger. AI is making the gap bigger because the speed at which AI creates, humans can't create that fast. So that's the first problem. Then your second issue is infrastructure, capacity, knowledge-based building. Who has the capacity to train the next generation on AI? Where is the expertise? Where is the facility to do that? And you can't do it in Indonesia as you are. You need that international collaboration. So you need in the agreements with the king and with the Indonesian government, you need that as a priority. And that's something as citizens that you can do because it's a democratic system and you can raise the need for that. Because if intellectual property is one issue, artificial intelligence is a whole other game. So it's really, really important to I think the awareness of it is your first step, but also collaboration.
Ya, jawaban dari pertanyaannya Mbak Sulis tadi adalah yang pertama mungkin perlu dipikirkan masalah capacity building, pengembangan sumber daya manusia, Makanya tadi seperti dicontohkan Inggris dan Saudi Arabia itu saling belajar dan mereka membuat perjanjian bilateral. Saudi Arabia memiliki sistem keuangan Islam dan kemudian Inggris belajar dari sana. Dan bagaimana kemudian setiap perjanjian bilateral yang disepakati Indonesia dengan negara-negara asing, dengan perusahaan-perusahaan yang mereka memiliki kecerdasan buatan, kenapa tidak dipikirkan adanya knowledge exchange atau pertukaran pengetahuan. Itulah mengapa salah satu syarat pasal di dalam setiap perjanjian investasi itu adalah transfer of technology. Nah, makanya transfer of knowledge dan transfer of technology. Nah, ini yang seringkali tidak dipikirkan oleh kita. Umumnya teknologi sudah kita beli, kemudian kita senang sekali begitu ya. Tapi begitu kita bongkar sendiri, kita nggak tahu caranya bagaimana merakit kembali teknologi yang sudah kita bongkar-bongkar itu tadi. Karena kita nggak punya knowledge. Knowledge-nya hanya bongkar-bongkar itu tadi ya. Sukanya bisa buka tapi nggak bisa nutup lagi gitu ya. Nah, itu untuk yang pertama. Kemudian yang kedua, infrastruktur. Ini pikirannya udah pada infrastructure capacity. Infrastructure capacity itu adalah kemampuan untuk membangun infrastruktur. Negara juga harus dipersiapkan untuk itu. Itulah mengapa perlu sekali dipikirkan bagaimana prioritas negara untuk menyikapi hal-hal semacam ini. Seperti di kejaksaan, di pengadilan, di perguruan tinggi, mereka pun juga harus siap dengan menyiapkan infrastruktur itu. Nah, ini Fakultas Hukum juga sudah menyiapkan ini. Sebentar lagi Pak Dekan lagi mendesain ruang Erasmus itu sebenarnya ruang metaverse. Jadi sebentar lagi kita akan beli itu kacamata yang harganya 30 juta, 20 juta itu mau kita beli, mau kita uji coba. Kemudian di bawah di semi basement sedang kita desain juga di studio yang mana kita bisa berdiskusi dengan Tun, berdiskusi dengan siapapun itu, tetapi dengan lingkup artificial intelligence. Ini sudah kita buat. Nah, bagaimana dengan yang lain? Kita kan nggak pernah tahu, tapi kita harus siap dengan infrastruktur itu. Do we need one more question? Satu aja ya. Mas ini aja. Oke. Ya. Saya pikiran lokal aja. Jadi AI itu kan kecerdasan buatan. Sebenarnya itu yang buat itu siapa sih dan mayoritas itu dari negara mana gitu. Apakah selanjutnya kecerdasan buatan itu apakah sudah dipatenkan saat membuat itu gitu. He's asking about the who owns the who creates the artificial intelligence, the root of the artificial intelligence. Do the owner of this the first of artificial intelligence protect their AI? And then pertanyaan selanjutnya apa tadi yang terakhir? When he creates the A1, do they also make the patent on that?
I know. So what they do is you can sell it. So you can create an AI code. You can have copyright. So you can have databases and you can have copyright protection, but you can't have a patent because you can't invent. So when you sell it, you charge a price for the AI code, and then I can use the code to create a patent, but then I will pay you to use your software. So that's how you're making your money back, but you're not getting a patent. Only the AI create. So if I use the AI. The owner of the first AI. So it's whichever company has developed it. So if I develop AI, I can then sell it to you. So everybody now has. Yeah, we're all using AI licensing. I mean, the grandfather of AI. Yeah, no, there's no grandfather of AI. There's
jadi
lots
AI
of software.
Ini sudah jadi semacam lingkungan. Jadi ya kalau teman-teman datang di Amerika Serikat, di negara-negara Barat, bahkan sekarang sudah di Arab Saudi, AI itu sudah diciptakan oleh setiap perusahaan di sana. Makanya sudah sangat disruptif sekali. Dan ketika kita membeli jasa AI ini, kemudian kita mendapatkan code gitu ya. Dan code ini bisa kita gunakan untuk menciptakan software, untuk menciptakan lagi. Jadi kalau teman-teman sekarang belajar teknologi informasi, mau menciptakan paten, mau menciptakan gambar dan lain sebagainya, teman-teman tinggal saja AI-nya, codingnya ya. Coding kalau kita namanya codingnya itu. Cuma saya nggak tahu coding itu apa.
They are making money.
Reality
because the AI is copyright protected. Source code you can protect using copyright.
Ada source code,
software is protected by copyright. So they're still making money. Don't worry.
Yeah.
But they don't have a patent. Not the AI company.
Yeah. I think that's all, and thank you. And again, kita beri aplaus yang meriah untuk Nadia. One thing that I need to revise the curriculum. Saya jadi punya pemikiran kurikulum kita perlu dirubah. Ada 1 mata kuliah, 2 mata kuliah tentang logaritma. Anak-anak yang sekarang kita kirimkan ke luar negeri, mereka ngambil mata kuliah capstone design, logarithm, and so on. Dan saya merasa malah Fakultas Hukum kita kok malah belajarnya nggak tahu ya, KUH pidana lama, pidana baru ya, acara perdata pidananya masih lama, KUH perdatanya yang lama begitu ya. Tapi kita tidak pernah belajar bagaimana menggunakan logaritma karena bahasa logaritma itu yang justru malah memudahkan kita untuk bisa bekerja di masa yang akan datang. Ya, ya dulu logika. Harusnya sekarang kan sudah naik pangkat jadi logaritma ya, dia. Ya, harusnya ada memang. Lawang matematika aja nggak bisa. Oh, ngitung kembalian aja masih pakai kalkulator. Mau mau belajar logaritma. Thank you very much again for Nadia and thank you very much. Do we need to have a picture, Farhan? I think we forget to make a picture, okay? I think it's better if we sit down here and Farhan will take a picture. Ya, atau mungkin geser ke sana biar kami duduk di depan.